Hi, thank you for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful David Duree, an Illinois construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous David Duree.
Fabulous might be a strong word. As a starting point, I would ask Jessie to go to the next slide, and we'll get right into it. We have three basic categories here: the contract, private projects, mechanics liens, and public projects, public works, payment bonds. And I would ask her to go to the next slide. The starting point of any lien claim by a subcontractor or general contractor is the contract itself, and that's why I included some topics about the contract, bearing in mind that subcontractors, suppliers, and general contractors have varying amounts of leverage in determining what will be in the contract. So if a general contractor says to a subcontractor, take it or leave it, sign my contract or else, you don't really have much to negotiate there. But for those contracts in which you do have some ability to negotiate, I'd like to mention just a few of the more significant clauses that would be in your contract. And I would mention that you should always have a written contract. Handshake agreements are nice among friends, but if you have a falling out, it creates lots of iffiness in your ability to collect what you think is due to you. The first is pay when paid clauses and pay if paid clauses, which means that the general contractor is obligated to pay the subs and suppliers only if the general contractor gets paid by the owner. And when the general contractor gets paid by the owner, the pay when clauses are usually interpreted to mean a reasonable amount of time to pay the subcontractor, even if the general contractor never gets paid by the owner. But the pay if clauses, if the general contractor doesn't get paid, the subs and suppliers don't get paid. So you should be on the lookout for those kinds of clauses. Obviously, the general contractor would like to have a pay if paid clause. The subs and suppliers would not. Arbitration clauses, a lot of standard construction contracts have arbitration clauses. There's a little bit of a built-in bias by any arbitration organization and arbitrator in favor of the party that controls the issuance of the contracts. So if it's a general contractor and they include arbitration clauses, there's a little bit of a bias among the arbitration organizations and arbitrators because they get all of their repeat business from the party that puts those clauses in the contracts, because without a written agreement, you're not obligated to arbitrate. So that's something to be on the lookout for, especially if you're a supplier or a subcontractor. Attorney fee clauses are important because they provide the leverage to whichever party has the superior position. The other side might be required to pay not only the attorney's fees of that party, but for the party opposing them. Termination clauses are important for anytime you have to resolve your contract one way or the other. And then the AIA standard contracts and subcontracts, which most of you are probably familiar with, have a lot of these terms built into them. So I merely wanted to mention things to look for in your contract if you have any leverage that you might want to negotiate or attempt to negotiate some of those clauses, either putting them in or leaving them out. Next slide, please. Your projects are broken into two major types, either a private project or a public project. For most public projects, you can't file a mechanic's lien. And but there is a bond that has to be provided by the general contractor once you get above a certain amount of the project. Really, most projects that you would be involved in would be above that amount. So the public body would be obligated to require the general contractor to provide payment bonds as well as performance bonds. On the private projects, really, for any type of claim of any significant amount of money, you should contact an attorney, because there's just lots of little issues that would trip you up if you're trying to represent yourself. And I'm speaking with respect to private projects, but public projects as well. On private projects, you need to get a legal description. Normally that would be handled by contacting an attorney who would get a legal description of the land where the building is located, which is needed for the mechanic's lien. Then you need to file a notice of intent to file a mechanic's lien within 90 days. And you have 4 months within which to either file a sworn statement of a mechanic's lien with the recorder of deeds, or file a lawsuit to enforce your mechanic's lien claim. You would have, for a general contractor, in kind of an exception to the 4-month requirement that's rarely comes into play, the general contractor would have 2 years to file a sworn statement of mechanic's lien or to file a lawsuit to enforce its claims. If there's no other lien claimants and no mortgage, in other words, no other claims to the real estate except the general contractor's mechanic's lien claim. Like I said, that rarely comes up because usually there's a mortgage, and usually there's some other contractor who has a lien claim. If you have a lien claim, there's probably somebody else that has one too. The next slide, please. As I mentioned, you have 90 days to file a notice of claim if you're a subcontractor or a supplier after the last work performed. With respect to the 2-year statute for filing a lawsuit to enforce your mechanic's lien, whether you're a general contractor or subcontractor or supplier, there is an exception to the general 2-year rule, and that is if the owner sends out a notice and has it served on you that you're obligated to file a complaint to enforce your mechanic's lien within 30 days, then you have 30 days to do so, or else your time for filing a mechanic's lien expires. The purpose of that is just to give the owner an ability to resolve any claims more quickly and not have to wait 2 years to see if someone files a lawsuit to enforce their mechanic's lien. Next slide, please. As indicated, subject to that exception, if the owner files a notice, you have 2 years to file your lawsuit to enforce the mechanic's lien, and you are entitled to recover interest at the rate of 10% per annum under the statute. And there's also a provision for single-family residences that you're obligated to, the general contractor is obligated to give notice to the owner and or occupier of the building, the single-family residence, that in the case of the general contractor, he's obligated to give notice that he's obligated to provide a list of all suppliers and subcontractors, and it is also obligated to provide a sworn list of all the names and addresses of the subcontractors. Next slide, please. And that notice is required in 10-point type, and most standard contracts that general contractors have established for their use for residential work will have that automatically built into their contract. And then in the case of single-family residences as well, each subcontractor must provide the owner or occupier with a written notice of its subcontract, the fact that it has a subcontract, within 60 days of the first work performed. But if the general contractor has already notified the occupier or owner of the single-family residence, the subcontractor does not have to give additional notice to the owner or occupier. Next slide, please. The other category of lien claims that you might have would be on public projects. And there's two types of public projects. There's the state public project, state of Illinois public project, or a federal project located within the state of Illinois. For the state projects, the public body involved, might be the Capital Development Board or some other state agency, is required to require the general contractor to provide payment and performance bonds if the public project is over $150,000, or for highway projects, Department of Transportation projects, if the project is over $500,000. And for those projects, the contractors, subcontractors, and suppliers may file a lawsuit against the bonding company as well as the contractor above them within 1 year of last performing work. If within 180 days after last performing work, they served a verified notice of claim on the public body, and within 10 days after that, served a copy on the general contractor. But all such lawsuits must be commenced within 1 year. There's a separate part of the Illinois Mechanics Lien Act. The Mechanics Lien Act that establishes a lien on public funds that are due the general contractor from the owner. To establish a lien on public funds, a supplier or subcontractor must give a sworn written notice of the claim. Now, there's no deadline for serving the written notice of claim, but it doesn't apply to any funds that the owner, the public owner of the project, has already paid the general contractor at the time the sworn notice of claim is served. So serving it quickly would be significant if, as a supplier and subcontractor, you believe that the public body, the owner of the project, owes money to the general contractor that has not yet been paid, and the general contractor is not paying you. And then after providing that sworn written notice of claim, it's necessary to file a lawsuit within 90 days thereafter to enforce the lien on public funds. Next slide, please. For federal projects, there's a federal statute called the Miller Act. It requires that lawsuits may be brought, don't have to be brought, but they may be brought within 90 days or at 90 days or later after the last work performed. But any such lawsuits against the Miller Act bonding company, the surety company, must be filed within 1 year. And any subcontractor or supplier that has a direct contract with a subcontractor, but not with a general contractor, must also provide written notice to the general contractor within 90 days of the last work. Any lawsuit must be brought within 1 year. And normally the practice, what I think is good practice and a practice that I've follow, is once I have a client who's unpaid and is claiming that it is owed money on either a private or public project, I start out sending notices of all kinds to all types of parties so that there's no possible claim later that they weren't notified of your claim. And I think we have one more slide here. I have had several cases where a public body was required to require the general contractor to provide a bond, a payment bond on a public project, but somehow failed to do so. Sometimes it just slips through the cracks. I had one recently where it was a school project, a general contractor had provided a bid bond to the school district for bidding the project. And after the bid bond was issued by the bonding company concluded that the general contractor was not that great of a risk because of some other matters that had occurred on other projects, and refused to issue a payment or performance bond. And somehow the school district failed to pick up on the fact that they did not also get a payment and performance bond. Under such circumstances, a supplier or subcontractor may pursue a claim against the public body because the public body failed to provide the payment bond required by the bond statute. Under those circumstances, the Illinois Bond Act is deemed to be a part of every contract. And the suppliers and subcontractors are considered to be third-party beneficiaries of the contract between the general contractor and the public body, which permits the suppliers and subcontractors to sue the public body because of their failure to provide a payment bond required by the statute. So that's pretty much a summary of things to be aware of when you're not paid, either as a general contractor, supplier, or subcontractor. But I would emphasize and restate, if it's any kind of significant amount of money that you don't want to lose, then you should contact an attorney. I'm not trying to build up business for attorneys, but usually people who try to represent themselves mess up somewhere along the way, and even though they have a meritorious claim, they wind up losing on it. So with that, I would take any questions.
First of all, David, thank you so much. That was really great information that you were able to provide for us. As for the questions, I do have a question that came through for us. It says, can attorney's fees and filing fees be included in my lien amount?
There is a provision in the Illinois Mechanics Lien Act under certain circumstances requiring you to make a claim for attorney's fees, but to really have a claim for attorney's fees that you think you have a good chance of success on, you should have it in your contract that in the event of a dispute and it becomes necessary to resort to litigation or arbitration, that the prevailing party will recover its attorney's fees, its reasonable attorney's fees, from the other side. There is that provision in the Illinois Mechanics Lien Act, but you have a far better assurance of getting your attorney's fees if you win the case, if you have it in your contract.
Great, thank you. And then another question just came through. It's, I think, along the same lines, though. It says, can I include an interest rate in my contract to charge my customer?
You can contractually agree to any reasonable interest rates, which are reasonable is considered to be pretty high. For example, you could put in your contract 1.5% per month compounded monthly, which roughly equals 20% interest, but you have to have it in your contract. As I mentioned earlier, the Illinois Mechanics Lien Act permits you to recover a 10% interest on your claims that are subject to lien rights that you enforce under that act. So there you have a 10% claim, even if it's not in your contract. But it only applies to those items which you establish that you have lien rights for.
All right, perfect. Thank you so much for answering those questions, David. All right, so if anybody does have a question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. All right, so who is ready to win a gift? We are testing your knowledge. Some of this David went over, so kind of put on your thinking cap, take a look at these questions. If you're able to answer these questions correctly in our chat, we'll go ahead and send you guys over a little prize. So here are the questions. In Illinois, when is the deadline to file the Miller Act notice for federal projects for a subcontractor or supplier? And then the other question is, in Illinois, when is the deadline to file the claim of lien? So take a look at those. If you're able to answer in, we'll go ahead and send you over a little gift. All right, here are some of SunRay's resources. So we're here to help you guys stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access the incredible resources that we offer. There's deadline calculators, there's project information sheets. There are so many resources available on our site. Please utilize them. We'll make sure that we're helping you guys ensure that you are getting your money and ensuring that you are retaining your lien rights. All right, so we have a new service available at SunRay. We are going to have our collections service. So it's SR Receivables will handle your collections for you. We're here again to help you guys get paid. So go ahead and you can reach out, call that phone number, or you can even email us and we'll go ahead and answer any questions for you. All right, our next webinar with David is don't sign a release unless it says this one thing. That's going to be Wednesday, June 19th at 1 p.m. Eastern, so 12 p.m. Central. So go ahead and register for free at sunraynotice.com/education. We'd love to be able to see you guys there. And then this one, if you don't mind, go ahead and scan that QR code, give us a review on Google. We really appreciate all of the feedback that you can give us, and it helps to get the information out to other contractors and suppliers like yourselves. And that is all we have for you guys today. Thank you guys so much for everybody that attended. Thank you, David. You were incredible. I really do appreciate your time. And we hope to see you guys at the next webinar. I hope you have a wonderful sunny day. Thanks again, everyone.